nicely matched.
Subcommittee will come to order without objection. The chair is authorized to declare recess at any time, and that may be necessary today because I believe we're going to have votes at 10:30. We welcome everyone today to today's hearing on oversight of the Department of Justice Antitrust Division. I'll now recognize myself for an opening statement. Assistant Attorney General Jonathan Cantor took the reins of the Department of Justice Antitrust Division 2 years ago this month. Today, the subcommittee will examine and conduct oversight of the Antitrust Division's approach during his tenure to date. The DOJ's refocusing of efforts and revision of antitrust guidelines raises questions for this committee. But it's not just Congress that has taken notice of DOJ's most recent actions or lack thereof. Patrick Hedger, Executive Director of the Taxpayers Protection Alliance, released a statement ahead of today's hearing which read, quote, "Working in tandem with the FTC, the DOJ this year issued revised guidelines the agencies will use in evaluating potential antitrust cases. The revised antitrust guidelines fly in the face of established antitrust precedent, which focuses on consumer welfare. The new guidelines signal these agencies will pursue cases to achieve policy objectives outside of consumer protection. Essentially, DOJ and FTC want to use antitrust as another tool of administrative fiat to circumnavigate Congress and bully companies into advancing progressive political and policy ends. The latest legal adventurism at these agencies is wasting taxpayer time and resources chasing novel legal theories beyond the mandate of Congress. These agencies are ripe to be reined in and refocused on basic consumer protection," end quote. The mission of promoting consumer welfare and promoting economic competition that defines the DOJ's Antitrust Division seems to have fallen by the wayside of DOJ's current initiatives and priorities. And the lack of transparency in which the DOJ operates raises many questions as to what those initiatives and priorities are exactly. We hope to get some clarity on that today. We've got a lot to get through, so I will yield back. I now recognize the ranking member, Mr. Correa, for an opening statement.
Thank you, Mr. Chairman. I also want to welcome Attorney General Cantor today. As you know, the United States, our gross domestic product, meaning our economic growth, is soaring. Unemployment, very low. But still, back home, many Californians are still struggling. And that's why I'm pleased to welcome you today to talk about the good work you've done. Your efforts include efforts to make sure workers are paid fairly, that small businesses can succeed, and that consumers are protected from artificially high prices. Your efforts have helped Californians, as well as many Americans, survive during these very difficult times. It's also important that Congress and DOJ work together to ensure small businesses can also thrive by assuring a plain level field, an even playing level field, by minimizing anti-competitive forces that hinder innovation or opportunities because consumers benefit from competition. Your testimony, your written testimony, you highlight some of the successes that you've had. You won a verdict against fraudsters who illegally obtained $240 million granted by the California Department of Transportation in fraudulent contracts. Thank you for that work. Generic price area, you reached deferred prosecution agreement against 2 generic drug manufacturing companies, resulting in criminal penalties of $250 million, and also divestiture of some of their drug lines. Again, ultimately, the bottom line is you help reduce drug prices for consumers in California and throughout the United States. Of course, a big issue is grocery store prices. And I applaud your efforts to stop anti-competitive practices that have led to increasing food prices at the grocery store. And back home, California families have been paying way too much for groceries, including chicken, pork, and turkey at the grocery store. Your antitrust division efforts have benefited many Americans by uplifting them and providing a level playing field for businesses. I support your efforts, but I do have some concerns. your expertise at DOJ, you have the primary authority to pursue antitrust enforcements together, I should say, with the FTC. In the airline industry, both the DOJ and DOT have long agreed that your department is a lead enforcement agency, and I agree. But I am concerned that the DOT, that is Department of Transportation, has indicated that they may well ignore decades of precedent and, more importantly, congressional intent, and will try to attempt to block mergers and acquisitions when your department at DOJ decides not to pursue legal action or fails to secure a verdict in court. I fear that if your department supports the DOT's efforts to become the enforcer of antitrust laws, this will erode your department's legitimacy and undermine this subcommittee's authority, and frankly, be a poor use of federal resources. Another area, the Hart-Scott-Rodino changes being proposed. It's my understanding that you have mentioned support for the changes to the draft merger guidelines and to the proposed changes to the Hart-Scott-Rodino pre-merger notification form, which the FTC developed in concurrence with the Antitrust Division. I've heard significant concerns from a wide variety of businesses with both of these efforts. And let me submit for the record, without objection,
Without objection.
an article dated October 4th on life science organizations opposing these new draft merger guidelines. A statement by the National Association of Manufacturers asking FTC to withdraw the proposed changes to the HSR form. Letter to chairs and ranking members of both houses, including ranking member Nadler, from a wide swath of businesses, including the Motion Picture Association and the Consumer Technology Association, also expressing concerns with the proposed HSR form. An article dated July 20th, 2023, quoting the former Treasury Secretary Summers, warning that the DOJ and FTC proposed guidelines on mergers and acquisitions seem almost like a declaration of war on business, if I can.
Without objection.
Mr. Cantor, again, I applaud the work the Antitrust Division has done to help American consumers, and I agree with your goals. But I caution the division that in following its mission to stamp out antitrust violations, it needs to be careful not to unintentionally harm competition or consumers. We need to make sure that no unintended consequences are actually created. And more importantly, that you don't hurt American jobs. Mr. Cantor, you and I have talked in my office many times, and we have similar stories, immigration backgrounds. My father was lucky many decades ago to land a good-paying, unskilled labor union job making cardboard boxes in Orange County. He wasn't the only one. Hundreds of workers in my community relied on that manufacturing plant's jobs for survival, to put food on our tables, health care, an opportunity for the future, and an opportunity for kids from the street to make it to Congress. Yet this employer was a big company, and more importantly, it was the source of a good union job. Thank you for joining us today, and I look forward to the discussion. With that, Mr. Chairman, I yield.
Thank you, Mr. Correa. Now recognize the chairman of the full committee, Mr. Jordan, for his opening statement.
I thank the chairman for his good work and for having this hearing. Thank Mr. Cantor for being here. Across the United States, there's ample evidence of collusion between powerful organizations. These groups join together to force ESG policies on American consumers and businesses and set policies to censor conservative voices. What has the Assistant Attorney General for the Antitrust Division done to rein in this blatant collusion among the most powerful financial institutions and companies in the world? Not much. But the Assistant Attorney General has inserted himself into trade negotiations. He's tried to strip protections for due process rights and competitions in trade talks. His tactics have worked, as the Commerce Department has backtracked on its initial position and no longer supports language from the Indo-Pacific Economic Framework that protects American businesses. The Biden administration is no longer supporting language that appeared in President Trump's U.S., Mexico, Canada agreement to protect Americans. The Assistant Attorney General may not be an international trade expert, but he should know that the protectionist policies by foreign governments like the Chinese Communist Party protect foreign businesses and create barriers for American business. Additionally, the DOJ under Assistant Attorney General Cantor has certainly done its fair share of losing. For example, he tried to litigate the same criminal price-fixing trial 3 times, resulting in 2 hung juries and ultimately the acquittal of all the defendants. The DOJ also has a losing record in civil cases. DOJ has lost 3 merger challenges and won only 1 merger challenge under the Assistant Attorney General's leadership. Based on this record, Assistant Attorney General Cantor needs to rearrange his priorities. I look forward to hearing from the Assistant Attorney General today and answer for his decisions. With that, Mr. Chairman, I yield back.
Chairman yields back. I now recognize the ranking member of the full committee, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, a fair, competitive, and open market is essential to ensuring economic opportunity for all Americans. A competitive marketplace means more high-quality jobs and the ability to negotiate higher wages or to switch employers. A competitive marketplace means small businesses, farmers, and ranchers will have more choice among suppliers and buyers, leading to more revenue that they can reinvest in their businesses. A competitive marketplace means entrepreneurs have space to innovate, experiment, and pursue new and novel ideas. And for consumers, a competitive marketplace means more choices, lower prices, better service, and a better quality of life. In short, a marketplace with robust competition is essential to preserving our country's role as the world's leading economy. Decades ago, the executive branch, with the assistance of the courts, took a radical turn away from enforcement of the antitrust laws, which had fostered competition and led to unprecedented prosperity for nearly a century. That failure by antitrust regulators led to massive consolidation across the marketplace and gave rise to a handful of dominant companies with the power to squash competition. The rise of monopolies and monopsonies in several fields was a boon to the corporate class, but it has been devastating to consumers, workers, farmers, and small businesses. I am pleased that the Biden administration has begun to turn the page and has announced several steps to reinvigorate the enforcement of federal antitrust laws, most notably through its 2021 executive order titled Promoting Competition in the American Economy. Since this order was released, the Department of Justice's Antitrust Division under Jonathan Cantor has risen to the challenge. The Antitrust Division is enforcing the law at historic levels, despite being under-resourced and understaffed. The division has the largest number of active civil antitrust cases in decades, affecting corporate consolidation across the economy. In agriculture, the division has cracked down on illegal schemes that raise the price of meat at the grocery store and suppress workers' wages. In healthcare, the division has achieved record criminal penalties against pharmaceutical companies that fix prices for generic drugs. It has taken on major cases to protect consumers in the technology sector and in transportation. In the housing market, the division is investigating collusion among landlords to keep rent prices high. And in government procurement, the division is rooting out collusion in public contracts for the military and elsewhere, saving millions of taxpayer dollars. Responding to the Biden administration's call to action, the Department of Justice, in coordination with the Federal Trade Commission, has released draft merger guidelines that reflect modern market realities, that are grounded in Supreme Court precedent, and that are the result of extensive outreach with the public over 18 months. Following passage of the Bipartisan Merger Filing Fees Modernization Act during the last Congress, the DOJ and the FTC have also announced draft changes to the Hart-Scott-Rodino Act pre-merger filing form, which will lessen the burden on merging companies and increase efficiency by giving the agencies the information they need to assess competitive effects early on. Thanks to the Biden administration's whole-of-government approach to competition, the economy is making historic gains, with rapid economic growth, low unemployment, and steady progress in fighting inflation after the economic shocks of the pandemic. By faithfully interpreting the original intent of the antitrust laws to ensure fair competition on prices, the division has announced that the party is over for large and unfettered corporations. Industry concentration can cost a typical American family $5,000 a year. Such concentration undermines the ability of Americans to support their families or to create the next successful business. That is why Assistant Attorney General Cantor is working to protect consumers, support workers, level the playing field for small businesses and farmers, and ensure our economy continues to lead the world. Thank you for appearing here today, Mr. Cantor. I appreciate the valuable work of the DOJ Antitrust Division and all that you do to support its mission. I look forward to your testimony, and I yield back the balance of my time.
Ranking member yields back without objection. All other opening statements will be included in the record. We will now introduce today's witness, the Honorable Jonathan Cantor. Mr. Cantor is Assistant Attorney General for the Antitrust Division at the Department of Justice. He was confirmed on November 16th, 2021. We welcome our witness and thank him for appearing today. I would also like to thank Mr. Cantor for making himself available to myself and Mr. Correa on an informal basis. We will begin by swearing you in. Mr. Cantor, would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect that the witness has answered in the affirmative. Thank you. Please be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony today in 5 minutes. Mr. Cantor, you may begin.
Thank you, sir. Chairman Massie, Ranking Member Correa, Chairman Jordan, and Ranking Member Nadler, and distinguished members of the subcommittee. It's an honor to appear before you today on behalf of the Antitrust Division of the Department of Justice. Antitrust enforcement is about economic liberty. A vibrant, open, and competitive market economy sustains a thriving democracy premised on individual liberty. Absent competition, real people suffer real harms. Consumers pay more for less. Farmers earn less. It's harder to start a business. The benefits of the competitive process are too myriad to list, as are the devastating consequences of markets that are beset by consolidation and collusion. Antitrust issues affect every aspect of American life. I'm mindful that next Thursday is Thanksgiving. For millions of Americans, the cost of air travel will decide whether they are able to make it home to see loved ones. Families getting together to share gratitude and turkey dinners are also facing the growing cost of putting food on their tables. For these American families, competition, or the lack thereof, has real consequences. Simply put, harm to competition means harm to real people. As law enforcers, we must remain steadfast in our efforts to hold wrongdoers accountable, especially when there's so much at stake. We are taking action where people most feel the effects of concentration. And we're having success. With your indulgence, I would like to share just a handful of our recent efforts. We have successfully blocked a de facto merger between two major airlines that would have caused harm to air travelers across the country. We won another large, complex civil trial to stop the proposed merger of two major book publishers that would have harmed authors, readers, and the free exchange of ideas. A small number of book publishers shouldn't decide which books get published and which do not. We brought numerous actions to protect small farmers, family farmers, from powerful middlemen, and to protect American consumers from higher prices at the grocery store. For example, we won commitments from chicken processors to pay over $90 million in restitution directly to slaughterhouse workers, and to stop anti-competitive conduct that directly affects chicken farmers. We recently secured over $220 million in penalties for criminal conspiracy by drug companies to raise prices, the largest fine ever for a purely domestic cartel. On top of that, we secured $50 million in free pharmaceuticals for people in need and forced the drug makers to divest the products at the heart of their illegal conspiracy. Our work also safeguards government and taxpayers from collusion and from fraud. According to the OECD, governments around the world pay 20% more for public projects due to collusion and bid rigging. To combat this, the division leads the Procurement Collusion Strike Force, which combats antitrust crimes related to fraudulent schemes that impact government procurement, grant, and program funding. In its short existence, the Strike Force has been amazingly successful. It has launched more than 115 criminal investigations, secured more than 50 guilty pleas and trial convictions. Most importantly, it saved millions upon millions of dollars for taxpayers. Mr. Chairman, with your indulgence, I may have to get your input so I can make my own tracker above my lapel, next to my lapel, so I can keep track of the skyrocketing number that we are saving for taxpayers by rooting out procurement and collusion fraud.
Just make sure it goes up and not down.
Yes, sir, it is. Quickly. We're also adapting our own tools to better meet the moment. That is why we are revising the division's merger guidelines to better reflect the law, and to address the realities of our modern economy. We are also building the technical and substantive infrastructure to address competition questions that arise in connection with artificial intelligence and other complex digital tools. And last year, we launched the broadest enforcement effort on record ever to enforce Section 8 of the Clayton Act, an important statute that prohibits individuals or their representatives from serving on the boards of competing companies. But we can't do this alone. Finally, I'd like to take a moment to share my regard for the Antitrust Division staff, some of whom are with me here today, my valued colleagues, but the entire staff of the Antitrust Division. They are among the most exceptional, talented attorneys, economists, paralegals, agents, and professional staff in the country. Simply put, I am honored each day to work with them. Because of their hard work and perseverance, I am optimistic that together we'll be able to meet the moment and the competitive challenges of our future. Thank you again for the opportunity to appear here today. I look forward to working with Congress to strengthen antitrust enforcement, and I'm happy to answer your questions.
Thank you, Mr. Cantor. We will now proceed under the 5-minute rule with questions. They have called votes, but I'm going to try and get a Republican and a Democrat in before we go to vote. So I'll now recognize the gentleman from California, Mr. Issa, for 5 minutes.
Thank you, Chairman. Attorney General Cantor, you wrote a letter along with the Federal Trade Commission Chair Lena Khan on March 22nd of this year. Do you remember that letter?
I do.
In that letter, I'll just a brief quote, you said that to the trade representative, and I ask unanimous consent to be placed in the record.
Without objection.
I'll quote, sets off concerns about the Indo-Pacific economic framework for prosperity, end quote. This framework, as you know, the IPEF, is President Biden's attempt to create a trade agreement without Congress being involved. You're familiar with that part of the quote, right?
I have not seen the letter recently, but I take your word for it.
Okay. Well, this document's highly redacted, and one of the questions I have is, under section number 2 of the letter, your letter, draft competition, we'd like to know what was under the redactions, particularly section number 3, where they even redacted what I believe is the word chapter. In the third one, what I can read is it's a draft competition chapter. I'm sorry, that's 2. 3. It says, have nor had the opportunity to review this provision, such as provisions could. We're not used to having this level of redaction on a non-classified document. Can you briefly tell us what you said in the third paragraph? Paraphrase it for us.
So I have to refer your request to our Office of Legislative Affairs. I believe they provided a confidential briefing, a bipartisan briefing to staff, and I'm happy to take your questions back.
So you write a letter between two parts of government, and then your people turn it into black lines, and you won't answer today. Is that correct?
I can't speak to the redactions. Again, we'll have to refer that to our Office of Legislative Affairs.
Okay, well, briefly, would you tell me, is it correct that you wrote a letter out of a concern for the trade representatives' handling of what is yours and the Federal Trade Commission's historic duty, that it might impact you without correspondence with you or particularly with Congress?
So what I can say is there is a process in place, one that Congress put in place, to make sure that the Department of Justice Antitrust Division has the opportunity to weigh in on issues that affect competition. Our goal is to make sure that we can enforce U.S. laws in U.S. courts, and there is an interagency process whereby we can provide information, questions, or concerns to other government officials who are responsible for negotiating trade agreements.
Are you familiar that currently there's a process where they sue in foreign countries or implement laws in foreign countries and then insist that in order for a company to do business there, they have to essentially make a worldwide agreement? This is particularly true on patents.
Again, I can't speak to the laws of other countries. I'm focused on making sure that we are enforcing the laws in the United States effectively and in U.S. courts consistent with our Constitution.
Yeah, well, I want to thank you for some past work done by your division. Department of Justice went after the airlines for price fixing, and there were actual convictions. American, United, I think Delta, I'm not positive it was Delta, but there were 3 airlines that were involved. And it went all the way to the CEO level. Do you remember that? Were you with them then?
That predated my arrival.
Okay, well, sounds like a good idea, but I happen to be in San Diego, and I can tell you that price fixing isn't just the money, it's also the routes. And I would say that DOJ has, having had those kinds of consent decrees, having had that kind of recognition of criminal conduct at the highest level of the airline industry, has failed to look at many areas, and San Diego happens to be one I'm experienced in which there is little or no competition, meaning, for example, from here, there has historically been one nonstop flight from Dulles, a group of flights. They belong to one airline, United. During the same time as the price fixing, American, which had a nonstop from DCA to San Diego, quite coveted, canceled it. Only recently, Alaska made a decision to add one flight. The response from United was to go from 2 flights a day to 3 flights a day, including a super jumbo 777, and run them empty in order to eliminate that competition. So I would strongly suggest that in addition to your heavy workload, that you relook at airline competition, not for the overt act of price fixing, but for the basic schedules that, in fact, show a convenience of not having overlapping so that each of them has, if you will, preferred routes.
Yeah, so we have prioritized enforcing the law as appropriate in this area, and we hear concerns from the entire country about the lack of affordability and availability of flights. We blocked for the first time ever in the history of the Antitrust Division a merger of airlines just last year, and we are in court as we speak at this very moment seeking to block another. And so we have prioritized this area because I said before, as we head into Thanksgiving, people are wondering whether they can afford travel across the country and have availability to see their family. And when people fly to see a sick loved one, they have the right and should have the right and the opportunity to have a competitive fare and competitive benefits of multiple routes.
Thank you. Yield back.
The gentleman yields back. And this is going to be the last question before we break for votes. I recognize the ranking member, Mr. Correa, for 5 minutes.
Thank you very much, Chairman. And Mr. Cantor, later on, let's talk about this airline merger, JetBlue and Spirit. I understand JetBlue is losing money, so I'd like to figure how they stay in business to continue to provide affordable airfares to our consumers. Bottom line, Mr. Cantor, I'm interested in keeping good middle-class jobs and growing them in California as well as the United States. And in California, big area for us, film, movie industry, and high-tech companies. These companies provide trillions of dollars of revenue, good jobs, union jobs, and they're taxpayers in California, some of the last taxpayers we have. The United States has taken the
Speak
lead.
for yourself.
We'll look at your disclosures later on, sir, and discuss that further. You know, when it comes to digital, the United States, in my opinion, still continues to lead the world. We probably have a 2-year lead on China and Europe, and both are trying to catch up. Both China and Europe are trying to get where the United States is. Last year, the Biden administration raised concerns that the European Union would not implement its digital agenda fairly, or the DMA. As it turns out, the administration was right. The European Union, through its Digital Marketing Act, or DMA, has targeted American companies for unfair treatment. And I would ask you, has anyone in the DOJ spoken to European Union officials at any point during the development or implementation of their DMA? The European Union has essentially designated gatekeepers. Of the 22 core platforms named as gatekeepers, 21 are US firms and 1 is TikTok. But no European companies have been named as gatekeepers. And Mr. Cantor, I would ask you, do you know why the administration has essentially changed course and stopped advocating for US interests? Or have we? Did the Department of Justice encourage the administration to change course or weigh in with the European Union policies when it came to designated gatekeepers? And before you answer that question, I have some articles that I want to submit for the record without objection. Thank you. A Political article dated January 31st, 2022. It says, U.S. pushes to change EU's digital gatekeeper rules. Bipartisan letters from both House and the Senate members raising similar concerns. Senator Crapo, Wyden, as well as Del Benny and LaHood.
Without objection.
And if I can, Mr. Cantor, just addressing my question in general terms, please.
Yes. Thank you, Ranking Member Correa. So I want to start with the most foundational principle, which is, as the Assistant Attorney General, Department of Justice, the Antitrust Division, my responsibility is to make sure that we can enforce U.S. law in U.S. courts in a manner consistent with our Constitution. It is longstanding tradition going back many administrations to make sure that we can protect our rights to enforce our laws domestically by having proper and appropriate coordination with jurisdictions across the world.
But my question was, did the DOJ weigh in with European officials as they were crafting the DMA and essentially naming mostly American firms as gatekeepers?
That is purely a matter for the European Commission. We have.
Did we weigh in on that?
Let me answer your question, sir, which is that we provided an observer after the rules were written so that we can understand how the rules may affect our enforcement domestically. And that observer was there for a few weeks and is now back home. But ultimately, when we interact with our counterparts abroad, it's done to improve coordination so that we can enforce our laws, U.S. laws, in U.S. courts.
Observer, fairness, equity, trade, it's a two-way street. We just observed and didn't opine.
You know, we regularly, and this goes back all administrations and where there's regular coordination. In fact, I have a letter I got from the Chamber of Commerce, or the United States Department of Justice got from the Chamber of Commerce in 2017, requesting more coordination because it often helps U.S. businesses when each of the jurisdictions with overlapping authorities understand what the other is doing. The goal of this work is to make sure we understand how it may or may not affect U.S. interests and specifically our ability to enforce U.S. laws in U.S. courts.
I'm out of time, Mr. Chairman, but I would like to follow up on that
Thank you.
comment later on. Thank you very much.
The gentleman yields back. The subcommittee will stand in recess until after votes conclude on the floor, and I encourage everybody to try to come back here as soon as possible, as soon as votes are over, and I appreciate the indulgence of the witness. Subcommittee will come to order. Now I'd like to recognize Ms. Hegeman from Wyoming for 5 minutes.
Thank you, Mr. Chair. I am concerned, Mr. Cantor, that some of the largest players in the investment industry are colluding and conspiring and using their power together to force environmental, social, and governance policies, also known as ESG, on American businesses and consumers. These institutions do not appear to care about the preferences of Americans. Instead, they want to force their agenda on everyone across this country, even if that agenda keeps Americans from having access to a robust choice of goods and services. Assistant Attorney General Cantor, Supreme Court case law makes clear that social justifications do not make anti-competitive collusion any less unlawful. And that's from Superior Court Trial Lawyers Association, a 1990 case. In other words, a desirable social policy does not excuse a violation of the antitrust laws. Is that correct?
Absolutely, that is correct.
Okay. And the Supreme Court has also made clear the court should reject requests from litigants seeking special exemptions or exclusions from the Sherman Act because of important social objectives. This means that there is no antitrust exemption for good social policy. Is that also correct?
That is also correct, and I commend you on your command of the antitrust precedents.
So regardless of whether the ESG policies are good or bad, if those policies restrain trade and lead to anti-competitive effects, then those policies violate the antitrust laws. Is that also true?
In all instances, we have to follow the facts and the law, and as the Supreme Court has said in other contexts, we don't engage in a balancing of social credits and debits.
The Supreme Court has explained that activity that prevents Americans from making free choices between market alternatives is inherently destructive of competitive conditions and may be condemned. This means that an agreement that reduces consumer choice can violate the Sherman Act. Would you also agree with that?
The Sherman Act and the antitrust laws exist to promote competition and choice, and that is a noble value, and our objective at the Antitrust Division is to make sure that we are enforcing the law to promote those values.
And quality, service, safety, and durability, all of these elements, and not just the immediate price, are considered in the antitrust analysis according to Supreme Court case law, correct?
Correct. I wholeheartedly agree that antitrust is not just about price. It is about quality, it is about innovation, and it is about choice as well, among many other things.
So competition results not just in lower prices, but also in better products. Would you agree with that?
I absolutely agree with that.
So even if an ESG policy that companies pursue together doesn't increase prices or decrease output, it still might violate the Sherman Act if it reduces product quality or limits the choices available to American consumers. Is that correct?
As a foundational matter, the antitrust laws are not just about price and output. The antitrust laws are about quality, innovation, and choice, among many other values.
Now, Mr. Cantor, you testified before the Senate when you were being considered for confirmation to your position as the head of the DOJ Antitrust Division, and you took an oath and swore to tell the truth at that time. Is that correct?
Yes.
And you took an oath to tell the truth today as well?
Yes.
At that hearing, you testified that, quote, the consumer welfare standard could encompass many factors beyond price, like quality and innovation and consumer choice, end quote. Do you remember that testimony?
I do.
Okay. You also testified that, quote, if confirmed, your focus would be to work with the Department of Justice to enforce the laws as Congress has written them and to make sure that we're protecting competition and the competitive process, end quote. Do you remember that testimony?
I absolutely do, and I agree with it then, and I agree with it today.
All right. Did you testify truthfully at your confirmation hearing?
I did.
And have you testified truthfully here today?
Yes.
Thank you. With that, I yield back.
Thank you.
Generally yields back. I recognize the ranking member of the full committee, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. The Antitrust Division had around 1,000 staffers in 1979, but today, even though the division is tasked with overseeing a bigger economy and companies that are bigger than some nation states, the division has just a little more than half that staff. Despite the lack of adequate resources, the division is enforcing the law at historic levels, reviewing over 3,500 transactions in your first year at the division. a record. Mr. Cantor, how is your work affected by insufficient resources, and how can Congress help support your work through appropriations?
So as the economy has grown, the complexity of antitrust cases have grown exponentially, and the amount of information and the significance of concentration to the American public has grown. We, as you point out, have over 200 fewer people today than we had in 1979, and that's against the backdrop of an expanding economy. It is essential that we have the resources necessary to keep pace with the issues that affect so many Americans, whether it's a farmer looking for a reasonable return on livestock, consumer looking for affordable air travel, or a consumer concerned about making sure that there's enough choice so that they can get access to private communication services. These are issues that affect every American and we care about deeply. Without sufficient resources, we can't adequately protect the American public from the harms that flow from anti-competitive conduct and unlawful concentration.
And you have half the staff that you did in 1979.
I go back and find the specific numbers, but when I started at the Antitrust Division, we had over 350 fewer people than we had in 1979.
Thank you. Recently, governments around the world have closely analyzed online market concentration. Governments from Japan to Brazil, Australia to the EU, and even our own committee have deeply investigated the online market, finding that the high level of harmful consolidation and anti-competitive conduct necessitates new rules and protections. In 2016, the Chamber of Commerce urged the executive branch to coordinate more closely with foreign governments, and I ask unanimous consent to enter their letter into the record.
Without objection.
Thank you. But now that such international coordination is resulting in real change, the Chamber is pushing back on the international coordination they called for so forcefully. Mr. Cantor, can you share the division's perspective on international coordination?
So first and foremost, our job is to make sure that we can enforce U.S. laws in U.S. courts. For decades, there's a bipartisan tradition of making sure that we have the appropriate level of coordination because we live in a global economy with international enforcers so that we can understand how their actions abroad and their laws abroad may or may not affect our domestic priorities. And so we've continued that tradition, but at all points, our goal is to make sure that we are enforcing U.S. law in U.S. courts and protecting our interest to enforce U.S. law in U.S. courts.
Thank you. The DOJ won a court victory in 2022, last year, that blocked a merger between two of the five big publishing houses, Penguin Random House and Simon & Schuster. I believe you referred to this in your opening statement. This decisive victory was premised on the fact that, according to the DOJ, the merger would be bad for workers. In this case, the writers would get paid less if the two companies consolidated. As you said of the approach, we said that workers matter. This kind of harm matters. In addition to this case, the department has also taken workers into account in the draft merger guidelines under consideration at the DOJ and the FTC. Mr. Cantor, can you speak more about how antitrust enforcement is critical for workers?
Absolutely. I think we can all know from our own personal experiences that when we have competition for our labor, we get better salaries, we get better benefits, we get better working conditions. If workers have choice, they can earn more money, they can be mobile, they can work not just doing what they want to do, but where they want to do it, whether it's in a rural community or an urban community. And so the antitrust laws were designed by Congress not just to protect the ability of consumers to get lower prices. That's an important objective of the antitrust laws. But it is essential that workers, particularly hardworking people working for an hourly wage, have the ability to benefit from competition.
Thank you, Mr. Cantor. I yield back.
Gentleman yields back. I now recognize the gentleman from New Jersey, Mr. Vandrew, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Assistant Attorney General, for being here today. You know, like most Americans, small business owners are struggling. They're struggling with an uphill battle against a stagnant economy, a struggling supply chain, and ongoing inflation and high interest rates. And the combination of these results cause operating costs to be higher and higher prices for the American consumer, and I don't want to get into all the reasons for that. But what many Americans might not know is about a hidden factor that is causing as much, if not more, direct financial pain in their wallets. Each and every one of those individuals out there pay it. Everyone sitting here pays it. Swipe fees. Swipe fees when you process a credit card, charged to the business, and sometimes passed on to the consumer. Believe it or not, and these numbers startled me, these hidden fees cost American families as much as $1,000 a month. Not a year, a month. In my state of New Jersey, swipe fees are set to cost residents a staggering $2.74 billion. Not million, $billion. And while we could debate all day on the causes and solutions to inflation, the reason swipe fees are so unfair, I believe, is pretty clear-cut. The duopoly of Visa and MasterCard. These corporations wielding control over approximately 80% of the credit card market, 80% of it. And they have set swipe fee rates that average 7 times higher than what those fees are, for example, in Europe and other countries. 7 times. That's a lot. It's unfair, it's unacceptable, and it's wrong. At a time of great financial struggle, it is unfathomable to me that this issue hasn't been addressed, and hopefully we will address it through legislation. But, sir, my questions for you are, Visa and MasterCard dictate these fees that banks must charge in order to accept their credit cards, and it seems like a classic violation to me and to others of antitrust. How can you tell this committee if the DOJ Antitrust Division is looking into this market duopoly and what work they're doing, and if so, what steps are be taking on what I believe is a very paramount issue?
So thank you for your interest and your comments. As I'm sure you appreciate, I can't comment on specific companies or specific matters, but I'm greatly appreciate your recognition that antitrust enforcement can lead to lower prices, it can lead to more competition, and it can lead to better outcomes for American consumers and in particular small businesses. And so without weighing in on any specific matter, I can say that preserving the ability of small businesses to save consumers money is an extremely high priority for the Antitrust Division.
So this costs small businesses a lot of money. It's gotten worse. It really is a problem. Can you, I don't ask you to even comment on MasterCard and Visa. I mean, we all know, everybody in the room knows who the elephant is, but can you comment on the idea of swipe fees and that there's so little choice? See, I believe when somebody processes a credit card, they should have a choice. When I say somebody, I mean a business of going alternate routes, but they don't. And we have legislation to work on that, and hopefully that will pass through this Congress. But I'd like to know if, just in the general idea of it, the concept, the philosophy, have you all looked at this at all?
So I greatly appreciate the question, and I want to take great care not to comment on any matter that may or may not be pending before the Department of Justice.
Not the answer I wanted. There's been a lot of recent challenges in the Antitrust Division. I know we've talked about a shortage of labor force there, and not to be challenging you, but we have had trouble in securing courtroom victories recently. I think we would all agree on that. Don't you believe that maybe instead of these really difficult challenges that you've had with courtroom victories, it might be better to look at these swipe fees? I guess what I'm asking you, at least from one congressman to one assistant attorney general, could you at least look at this? It's a real big deal. People would appreciate it. It affects everybody, what age, what color, what, income category, then every single person in America is affected by this.
Yeah, I understand that, and I'm sure we can talk about it, but extremely proud of our court record, including our numerous victories, but none of that comes to the exclusion of looking at other issues that have a significant impact and resonate with the American public and small businesses.
I don't want to exclude other issues, but I want you to look at this issue.
I duly noted, sir, and I appreciate your question, and I will make sure that we take that back.
Thank you. I yield back, Chairman.
Gentleman yields back. Now recognize Ms. Jayapal for 5 minutes.
Thank you, Mr. Chairman. Assistant Attorney General Cantor, thank you so much for your leadership and for the critical work that your office is doing to revitalize antitrust enforcement and promote robust competition. You entered the Justice Department with bipartisan support from 9 former antitrust division heads And in your brief time with DOJ, the Antitrust Division has already won its first criminal antitrust case against employers that sought to suppress pay and prevent workers from switching jobs. You've opened investigations into corporate monopolies like Ticketmaster. You've secured huge settlements for American workers, for small businesses and consumers, and you continue to vigorously defend our economic security and privacy interests in court against big tech giants like Google. Now, I know I've heard some of my colleagues say that, that there are businesses that are concerned about some of the work that you're doing, and I'm not surprised, because for the first time, their lobbying efforts on both sides of the aisle are not necessarily working, because for the first time, we have a Justice Department and an Antitrust Division that is actually promoting competition and using the tools that you have. So I, for one, am very grateful. I am disappointed that our bipartisan efforts to strengthen competition have stalled in Congress, but I'm proud that we're doing what we can to put antitrust considerations front and center. That's why I worked with Ranking Member Nadler to send a letter yesterday urging the White House counsel's office to integrate competition-related questions into the administration's judicial vetting process. I seek unanimous consent, Mr. Chairman, to enter into the record that letter to White House counsel and the letter I signed to President Biden requesting that any digital trade provisions of an Indo-Pacific economic framework are consistent with his whole-of-government competition policy agenda.
Without objection, so ordered.
So, Mr. Cantor, I understand that you prefer to litigate cases to a decision instead of seeking settlements. Can you briefly explain why?
Yes, so we will always entertain remedies when they are sufficient to solve the competitive problem. What we are not going to do is put the risk of a failed remedy on the shoulders of the American public. At the end of the day, antitrust is law enforcement. It's about the rule of law. We follow the facts and the law wherever it takes us. We bring cases to courts, and we focus on convincing courts to protect competition for the betterment of the American public. Again, we'll always listen to a settlement proposal if it solves the problem. But what we're not going to do is we're not going to ask the American public to shoulder the burden of a failed settlement.
Under your leadership, the Antitrust Division has helped revive the enforcement of our nation's antitrust laws after decades of neglect. How is your division also creating a new antitrust language that remains accessible to everyday Americans and reflects how they think about competition?
Wonderful. So we've created what we call an antitrust access to justice program, nicknamed AT2J, and it focuses on making sure that antitrust, which is the people's law, is accessible to the people. Antitrust for too long has been the exclusive domain of a small number of folks inside the Beltway who use exclusionary words and terms and have excluded the participation of farmers, of workers, small business owners. These are the people who are directly affected by corporate concentration. And so it's important that we make efforts, whether it's in how we revise our merger guidelines, how we manage our citizen complaint portal, how we go about seeking comments on mergers and acquisitions to include the public, because the public matters. We are doing this for the public. We need their input. And guess what? They know what they're talking about. Small businesses, consumers, workers, they get it. They understand their industries better than we do. And by going out and talking to them, we can learn what we need to learn in order to enforce the law effectively.
That's fantastic. The American people, I think, would be shocked to learn that despite overseeing a bigger economy with more companies and more mergers, the Antitrust Division has been operating today with half the staff that the Carter administration had in 1979. Mr. Cantor, while we in Congress have a duty to provide your office with the funding and resources you need, can you just highlight how your office has been able to continue protecting consumers and promoting competition by forming strategic partnerships with agencies like the FTC and the FBI?
Absolutely. So the whole of government approach is really important. There are competition statutes and rules that Congress enacted that exist throughout the government. And so the Packers and Stockyards Act is a great example of the U.S. Department of Agriculture. The Department of Transportation has competition-oriented statutes that they enforce. The FCC has long had concurrent jurisdiction with the Department of Justice on certain types of telecommunications and media transactions. These are important efforts. Competition policy is important to making sure that businesses have opportunity and that our economy has the ability to grow.
Thank you so much. Mr. Chairman, I seek unanimous consent to enter into the record a letter that Senator Warren and I sent to Google calling on it to cease efforts to bully Assistant Attorney General Cantor into recusal, and just want to be clear that I and many of my colleagues staunchly oppose those efforts.
Without objection, so
Thank
ordered.
you. I yield back.
The gentlelady yields back. The gentleman from Colorado is now recognized for 5 minutes.
Thank you, Mr. Chair. Welcome, Assistant Attorney General Cantor.
Thank you.
The United States has a long history of fighting against trusts. And in fact, there was a debate during the drafting of the Constitution about trusts, and we even, our country's history goes back to fighting against the East India Company, and certainly many Americans have heard about the Tea Party. They haven't heard about the antitrust side of the Tea Party, but they've heard about the taxation side of the Tea Party. But in 1788, Thomas Jefferson wrote to James Madison, "It is better to abolish monopolies in all cases than not to do it in any," to which Madison replied, "Monopolies are sacrifices of the many to the few. Where the power is in the few, it is natural for them to sacrifice the many to their own penalties and corruptions." When I was in law school, I took a class on antitrust and remember absolutely nothing from that class. But I do remember there was a case in that town, small town, where 6 gas station owners would get together on Monday morning and they would set the price for gasoline at the retail pumps in town. They owned almost all of the retail pumps. And you would be surprised to learn that they set the price above the price that was prevalent in other areas, and they made more profit as a result of that little coffee they had. They were prosecuted by the Department of Justice, and I said prosecuted. They were criminally charged by the Antitrust Division, and that stopped. And prices came down. Not a revolutionary thought to most of us, but the work of the Antitrust Division for well over 100 years has been instrumental in the prosperity that we enjoy in this country because of the competition that has been spurred by that. I want to just go over a couple of cases and just get a quick answer before I ask you a more general question. But Standard Oil case in 1911, did it increase competition, reduce prices?
Yes.
What we refer to, the U.S. Steel case, 1948, increased competition, reduced prices for consumers?
Yes, sir.
How about the Ma Bell case, 1983?
That one too.
And one of our favorites, because it happened when we were all sort of thinking about post-Reagan, Bork antitrust enforcement, but the Microsoft case in 2000.
Yes, antitrust has spurred not just lower prices, but more innovation.
So I do remember some things from my constitutional law class, and I do remember that in Article 1, the power is given to Congress to legislate, and not to the Article 3 courts. I have a vague memory, and some people, based on a vote that I took yesterday, are saying that I've lost my mind, but am I right in that?
I seem to recall that your articulation of the Constitution is correct.
In general principles, principles. So who developed the consumer welfare standard?
It was not Congress.
It was the courts.
Which one? So if you asked 5 antitrust lawyers, what is the consumer welfare standard, you'll often get 6 different answers.
Okay.
A standard isn't a standard unless everyone agrees as to what it is.
But you won't find a single statute where the consumer welfare standard is defined.
That is correct.
And we now have a much different economy than we had 50 years ago, 30 years ago, with the advent of e-commerce and really online everything. In fact, if you had been here a year and a half ago, this probably would have been online with members participating virtually in this hearing. Based on that drastic change in the economy, has Congress kept up with its duty to legislate?
So I take very seriously, and consistent with your words earlier, that it's ultimately up to Congress to determine how to legislate and to write the law. As an enforcer, it's our job to enforce the law as you write it. I deeply respect that division, and we will make sure that we are enforcing the law and using our taxpayer resources to bring about the vision that Congress sets forth in its statutes.
My memory from being in DOJ years ago is that I think there are 93 districts, judicial districts in the United States?
Yes.
Oh, good, I have a good memory. And in those 93 districts, if you went to each of the district courts and asked for a ruling on cases, you would get a variety of answers. But if you come to Congress and ask for an answer on big tech, you'd get one. What is the need for, and what would you prioritize in terms of our job to legislate on big tech?
So again, I want to be very deeply respectful that ultimately it's the prerogative of Congress to write the law, and it's our job to enforce the law as you write it. From time to time, we provide technical assistance or views with respect to pending legislation. We did that in the last Congress, including with respect to legislation that you sponsored, providing our input. But as I said before, and as you indicate from your questions, it is extremely important that in antitrust law, we respect that it's the words of Congress, that Congress writes the law and we enforce the law as written by Congress and ultimately interpreted by the Supreme Court.
I yield back, thank you.
Gentleman yields back. The gentleman from Georgia, Mr. Johnson, is now recognized for 5 minutes.
Thank you, Mr. Chairman, and Assistant Attorney General Cantor, thank you for being here today and for your testimony and for your work on behalf of the American people. You've heard the term used, defund the police, correct?
I have heard that, yes.
And you've also heard my friends on the other side of the aisle talk about defunding the DOJ, haven't you?
I have heard that from time to time.
And recently, you testified that the Antitrust Division has almost 400 fewer employees than it did in 1979, despite its mandate, which is to police an economy where the rich and the powerful have become more rich and powerful, and where workers have been lowballed and consumers have been paying higher prices. The work of the Antitrust Department is vital to ensuring that our economy thrives, that our consumers can afford to purchase goods, and that our workers are paid fair wages for the work that they do. Mr. Cantor, you've spoken about how the DOJ lacks the resources to enforce our nation's antitrust laws as robustly as possible. How can the DOJ's capacity for antitrust enforcement capacity be strengthened?
So thank you for the question. You're right, even sitting here today, we have significantly fewer resources and personnel than we did in 1979. These are complex cases. They involve a lot of data. They involve a lot of technology and a lot of resources. And it's imperative that we have the people necessary given the scope of the concerns. We deal with issues from agriculture to healthcare to pharmaceuticals to energy to technology. And in order to enforce the law as Congress wrote it, we need sufficient resources to make sure that we are fighting to protect the American public. And we will put those resources to good use as Congress determines and sees fit.
Last year, under Democrat control of the House, we passed the Bipartisan Merger Filing Fee Modernization Act, which was signed into law. How does that bill help the DOJ improve antitrust enforcement?
The Department of Justice came out in strong support of that legislation, and we're extremely grateful to the Congress and for the overwhelming bipartisan support for that legislation. It ensures that the merger filing fees are updated for the first time in roughly 20 years, and that those fees can help fund or available to help fund the Antitrust Division, and so that we can protect the American economy. I should note that it also continues a longstanding tradition, which is that we are, significantly fee-funded component, which means our burden on the general fund, our burden on taxpayers, is quite minimal.
Thank you. Despite incessant attempts to defund your operation, you've robustly enforced our nation's antitrust laws, from opening investigations into Ticketmaster's anti-competitive conduct and pursuing litigation against Google's monopoly in online search and online advertising. Why does the DOJ need help from Congress in order for it to be able to more robustly enforce the nation's antitrust laws?
Ultimately, it's, as I said before, it's the prerogative of Congress to write the law. And if Congress sees fit, based on the challenges in our economy and the expansive corporate concentration, to update or clarify the laws in order to provide more authorities, then that is the role of Congress. And in some instances, the DOJ has provided technical assistance or specific support. At the end of the day, again, that is, it's all about the rule of law, and we need to make sure that we are enforcing the law effectively. But until that time, we will make sure that we use the resources that we have to enforce the law to the greatest extent possible to help as many people as possible during our time.
Thank you. During the coronavirus pandemic, it was essential workers who stepped up to the plate and continued to help their fellow Americans despite their risk of exposure. And despite their heroic work, companies that employed these essential workers also worked to suppress their wages and restrict their job opportunities. In light of these illegal actions, the DOJ enforced the law and won indictments against these lawbreakers, including 4 managers of a home health care agency or home health care agencies in Maine. Why is it important that DOJ act on behalf of workers like these health care practitioners?
These people are the beating heart of our economy. They put themselves in harm's way as healthcare workers, and people work hard, and they should have the benefits of competition. If you indulge me, I think about an email that I saw in one of our investigations. This was a woman who was an in-school nurse for children with special needs, who couldn't afford her own health insurance. She couldn't afford her own health care, and tried to get a better job and couldn't because of an anti-competitive agreement that prohibited her from going to another employer. These are real effects for real people, and we have an obligation to fight for them, to make sure that they are able to have the pathway to upward mobility and to earn a decent living based on their hard work.
Well, thank you for your efforts, and I yield back.
The gentleman yields back. The gentleman from Florida, Mr. Gates, is now recognized for 5 minutes.
Mr. Assistant Attorney General, I think you're doing a good job, and that is a painful admission for me to have to make about anyone who works at the Department of Justice, an entity that I believe has been victimized by political capture. But I am perhaps just as concerned about the monopoly power of Google. Please talk to us about the enforcement actions that you have led against Google.
Thank you for your question. We have, it's a matter of public record, 2 open enforcement matters against that defendant. I can't speak specifically to those matters because they're pending in court, including one right down the street as we speak.
Well, we heard the chairman of the committee critique your work and say that the real problem is you keep losing, that you guys are losers. You're not getting victories. But you're just not speaking about the merits, but the procedural posture regarding one of your cases against Google. You're in trial right now against Google, right?
Correct. Yes, we have 2 cases, one of which succeeded on the summary judgment, the other that survived a motion to dismiss.
While I'm a few years away from my time as a practicing lawyer, usually when you're at trial, that means you've prevailed on summary judgment, right?
Correct.
And usually it also means you've prevailed on motions to dismiss, right?
Correct.
And sometimes you got to prevail on multiple motions to dismiss, don't you?
From time to time.
And in the other matter, where you're not at trial against Google, but you're making really important allegations about how Google has vertically integrated advertising, brokerage, and advertising monetization. In that matter, you have prevailed on the motion to dismiss, right?
As a matter of public record, that matter prevailed on the motion to dismiss.
So are you tired of winning?
Well, I can give you a whole other list of our victories, including in court against mergers. We've had...
Well, I want to stay on big tech because
okay.
It's really concerning to my constituents. Why should our fellow Americans be concerned about any entity that has the ability to vertically integrate search and ad brokering?
So I think it's important to go back to the foundation, the formation of the antitrust laws. In preparation for this hearing, I went back and looked at the namesake of the Sherman Act, John Sherman, and he said at the time that the law was passed, if we will not endure a king as political power, we should not endure a king over the production, transportation, and sale of any of the necessities of life. Ultimately, monopolies threaten our liberty. And if companies engage in anti-competitive conduct, exclusionary conduct, or break the law in order to sustain their monopoly power, it threatens our liberty and threatens our democracy and goes to the heart of our freedom. And so we have an obligation to enforce the law.
I would double tap the importance of that in the information space. I'm proud of the work that you've done for food processors and to stop consolidation in our food supply. I'm very worried about that. And I think that the work you're doing on the supply chain as well is really critical to drive down inflation, help our fellow Americans. But in the information space, if you get these powerful monopolies that get to define the nature of truth itself, it really is a threat to the republic, isn't it?
This is the marketplace of ideas. The free flow of information is critical to a free and open society. It's right there in the Constitution in the First Amendment. And when companies control the information highways, they control access to information, it threatens the marketplace of ideas.
I want to encourage you to continue to pursue those cases, because a dynamic that I've observed at DOJ, and it's not a criticism of you, but of others, is that what they want to do is go create these enforcement actions that are just enough virus for those people to then go and sell the antidote when they leave DOJ and go work for some big high-priced law firm. So they go create a little virus, then they go sell the antidote. I don't think that's what you're doing. And sometimes that means you have to take some intermittent losses along the way, but when going up against the toughest and the worst companies, it seems as though you've got the human resources and the financial resources to pursue that. Am I correct?
I have a job to do, and we are going to enforce the law without fear or favor. And sometimes when you go up against the biggest companies in the world, it results in attempts to intimidate you not to do your job, but we're not going to be subjected to that intimidation.
Well, I think you're doing your job, and frankly, I think we would do our job if we continued to advance the legislation that Congresswoman Jayapal and Congressman Buck and I worked on to reshape some of these companies by force of legislative power. There's a competing doctrine here. There are some who just say, strip some of these monopolies of their defenses and send you all and other lawyers off to feed on them. But in a way, that's an abdication of our Article I authority to be able to reshape these entities that are impairing the marketplace of ideas. So I really hope we would get back to that Jayapal legislation and to run that in tandem with the good work you're doing.
Rule of law starts with the laws written by Congress.
Thank you.
The gentleman yields back, and I'll recognize Ms. Scanlon from Pennsylvania for 5 minutes.
Thank you, and thank you, Assistant Attorney General Cantor, for joining us today in an era of increasing concentration and anti-competitive behavior. Really want to commend you in the Antitrust Division for your efforts to strongly enforce our existing antitrust laws against monopolies in a whole range of industries, as you've suggested. We've heard some mention of Google's anti-competitive practices, and you mentioned there's a couple cases right now. As you and your staff are aware, during the last Congress, this subcommittee, under the leadership of the former chair from Rhode Island and our colleague, Mr. Buck from Colorado, undertook an extensive and largely bipartisan examination of anti-competitive practices of the largest tech companies, including Google. I know your current cases, one is regarding Google's dominant position in online search, and the other on Google's control over online advertising, as we've suggested, have the potential to promote competition and fairness in an industry that has been dominated by a handful of large companies. I've found it particularly interesting that the Department of Justice's online search case has revealed some shocking practices, including that Google paid $26 billion 2 years ago to make its search feature the default on iPhones and most internet browsers. I think that's important information for the public to know as we talk about the importance of fighting anti-competitive behavior. It defies logic to see how an industry can be deemed competitive if one company can afford to pay its competitors not to compete. And as you engage in these prosecutions, I see some takeaways. While I understand that in certain cases settlement might be an appropriate choice, I do think the sunlight that is provided by public prosecution is important. A second takeaway would be that the discovery and public disclosure of evidence is necessary, as I said, to help the public understand what these companies are doing and how it impacts our consumers and small businesses. And if there is trouble moving to a successful conclusion of those cases, I suspect it will be not because Google's actions were not anti-competitive, but that we may need to update some of our 100-year-old statutes that are in your legal toolkit to go after monopolies. And I would appreciate any suggestions you have in how we might do that, understanding that you might not be able to refer to the cases currently under prosecution.
And thank you for the question. And as I indicated before, I can't comment on active litigation matters, but I very much appreciate your recognition of the hard work of my colleagues, some of whom are with me today, and many of whom are in court today and back at the Department of Justice, who work tirelessly at great personal expense to fight for the American public, and I'm so proud to call them colleagues. With respect to the role of Congress, as I mentioned before, the rule of law starts with the writing of the law, and ultimately that is the prerogative and the role of Congress. And as a law enforcement authority, we have to enforce the law using the tools that you give us. In the last Congress, there was robust discussion in this committee about changes to the law, and we've provided input based on our technical understanding of those proposals and our views, and we're happy to reshare that with the committee and working through our Office of Legislative Affairs, provide input as appropriate.
Yeah, I mean, some of those bills, the American Innovation and Choice Online Act and the Access Act, were designed to improve antitrust enforcement and promote competition. So we are very interested in your views and your colleagues' views on how those would help us move forward. I see my time's almost up. I think we are going to submit some additional questions. I have been talking with some of our colleagues overseas in the EU, in Ireland, about some of the measures they've been able to move forward with. They're far ahead of us, and obviously we need to either catch up or buy in. So I'd be interested in submitting some additional questions on those issues.
Thank you, and I very much look forward to answering your questions.
Okay, thank you. I yield back.
The gentlelady yields back. The gentlelady from Indiana, Ms. Spartz, is recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Cantor, for being here today. We talk a lot about, monopoly, oligopoly problems, and you talk about individual liberties. But we do have a serious problem in every sector of the market with oligopoly, monopoly problem, whether it's healthcare, whether it's agriculture, whether big tech. And there are things that you take in tough cases, and I actually appreciate that you're willing to take tough cases. I actually had some agreements, even on bipartisan basis, to adjust our legal framework. Yeah. We cannot just allow companies to have unlimited immunities. We cannot allow companies not to have proper accountability and protection of property rights, including data protection, because that's become a new type of property, and we didn't define them. We do have challenges with consumer welfare standard, which maybe need to be defined a little bit more broadly and everything else. But don't you believe, we pass a lot of different laws, but in reality, you're treating the symptoms, but it seems like a lot of your cases, you get dismissed or have weak evidence, you're really treating the symptoms. But unless we start looking at the causes, we passed Dodd-Frank for too big to fail. Our institutions became even bigger. So don't we need to start looking at barriers of entry and barriers to market competition of entry?
So absolutely. When we deal with monopolization concerns, we need to go make sure that we're focused on core monopolies and core considerations or conditions that, if they violate the law, sustain monopoly or oligopoly positions. And so we've undertaken that effort in our investigations.
But you can do only symptoms. The barriers of entry that we create in a lot of ways, either through USDA regulation, either through bills, you cannot deal with that. Is that correct?
Well, we are a law enforcement
You
authority.
cannot come after USDA, right? So we are the only people who can, right, enforce if our agency creates barrier of entry. Is that correct?
So again, we are focused, I have a very narrow job, is to enforce the antitrust laws as written by Congress.
Right, so I think the challenge is you will not be able to deal with this, and it's become very ineffective. We have oligopoly problems in every sector of the market, is that correct?
Well, I think we have...
In most.
In many markets, there are monopolies and oligopolies. I do believe that antitrust enforcement can be an effective tool, and when the facts and the law support it, to help promote competition. You can't have a functioning marketplace without market participants.
Right, and so generally barriers of entry, if we don't have new entries too, that causes significant problems, is that correct?
There can be many causes to barriers of entry, yes.
Right, so, and a lot of them are legislative.
I will defer to Congress regarding legislation. Again, I'm focused on anti-competitive conduct that violates the law.
So what are your thoughts about the consumer welfare standard? What are your thoughts about that?
So as I indicated before, I think if you ask 5 antitrust lawyers, what does the consumer welfare standard mean? You often get 6 different answers. It's difficult to have a standard if there's no broad-based agreement as to what it means. The welfare of consumers is an important objective. It's an essential objective for the antitrust laws, but so is the welfare of workers, so is the welfare of
But it's probably,
innovators.
in some cases, it's more just than price, correct?
It's absolutely more than price.
Right, but it's very difficult to argue in any other cases, if it's not a price. It's becoming much more difficult because precedent has been just a price issue, is that correct?
Well, I think we have an obligation to make sure that we are bringing cases to courts that present issues in the way they appear in the marketplace. And sometimes that will be in the form of higher prices, but sometimes that might be in the form of less innovation or harm to, for example, the marketplace of ideas.
Access. One more question. So we had a kind of discussion, and it's a very convoluted process, your relationship with FTC and DOJ. If you would literally look to restructure that process, because it's very strange how it's set up, how would you do that to make it more efficient antitrust enforcement?
If you beg my indulgence, I think my kids would answer that by saying, new phone, who dis? So I think ultimately it's up to Congress to create institutions and determine how those institutions and what their authorities are. And ultimately, at the end of the day, I've got a job, which is to be an antitrust enforcer at the Department of Justice, and I will focus on doing that job to the best of my ability and with the trust of the public.
So do you believe you efficiently set up your agency as you're in charge of your division? Is your division set up as efficient as it can be, or there are some improvements in your division that we should address for your division specifically?
Yeah, there are always improvements.
But can you state some?
Yeah, we've for example, we've looked to make our information more accessible to the public, to change the language of antitrust. We've opened investigations that focused on labor effects. We have created organizational streamlining to make sure that processes are more efficient and decisions can be made more expeditiously, but with the same level of protections and oversight. We are constantly making sure that we are evaluating how we run our divisions so that we can deliver the best results for the public as efficiently and as inexpensively as possible.
Thank you. My time expired. Yield back.
The gentlelady yields back. I'm glad to see my good friend, Mr. Neguse, is also skipping the other hearing we're supposed to be in on our Rules Committee, and I appreciate him coming to attend this, and I I recognize Mr. Neguse from Colorado for 5 minutes.
Well, I certainly thank the chairman. I wouldn't miss a hearing being held by Chairman Massie, so glad to be here, and grateful to him and Ranking Member Correa for hosting this hearing, and of course, welcome back to the Assistant Attorney General. We're grateful to you for your hard work at the Department of Justice and for the work of all of the folks within your agency that they are doing each and every day to protect the public and to protect consumers. I really think that the work you've done, and of course in partnership with the chairwoman of the Federal Trade Commission, Chairwoman Khan, has been incredibly important and meaningful in terms of putting consumers first, fighting against monopolistic power. And as we've heard during the course of this particular hearing, and I suspect you've heard elsewhere, that kind of work obviously offends the concentration of power in different places, and the blowback that ensues is not all too surprising. But nonetheless, we're grateful for your diligence in returning the Antitrust Division's work as mandated by Congress under the Sherman Act and the Clayton Act, efforts that, in my view, were long overdue. I want to talk a bit about the merger filing fee bill, which, as you know, we passed last year. The Congress had enacted it, President signed it into law on a bipartisan basis, passed overwhelmingly in both chambers. It was an effort that I was proud to lead alongside my Republican colleague from Colorado on a bipartisan basis, Congressman Buck, which essentially would ensure that the DOJ and the FTC had the resources that they so desperately needed from an antitrust enforcement perspective. You noted, I believe this was last year in your testimony to the United States Senate, that your division is operating with 400 fewer employees than it did in 1979. And that was at least at that time that you were testifying, and I suspect it hasn't changed materially. Of course, that was before I was born. So you think about all that has changed over the course of the last half a century, well, actually less than half a century, 40 years, and yet you all are operating with less people than your predecessors did. The merger filing fee guidelines were intended to help change that, the Modernization Act, I should say. Unfortunately, it appears that the budget that Republicans have proposed for the next fiscal year contravenes that congressional intent that we had all arrived at in terms of a consensus less than a year ago, because the budget that my colleagues on the other side of the aisle have submitted would only further cut your already insufficient funding levels and prevent you from carrying out the work that is so needed to protect American consumers and small businesses. I think it'll have a lasting impact. I'm curious if you might want to expound a bit on if the current proposed levels in the appropriation bill that we're taking up today in the Rules Committee, as Chairman Massie mentioned, if those levels were to be enacted into law, how would that impact or, in my view, impede the work of your agency?
Thank you, Congressman, and thank you for your work and your leadership on the legislation from last term. Indeed, it provides much-needed available funds for the Antitrust Division so that we can enforce the law, which, as you indicate, covers the entire economy. The work that we do lowers prices for consumers. It saves taxpayers millions upon millions of dollars in collusion and procurement fraud. It opens up opportunities for new businesses to start and thrive. The return on investment from antitrust enforcement is a multiple that would be the envy of Wall Street. And so we are working to make sure that we can take the scarce resources that we do have and invest it efficiently and effectively to the betterment of the public. And I'm proud of what we've been able to do with the little that we have. But as you indicated, we are still substantially smaller today than we were in 1979, and with greater resources, we can do more to protect the public and save taxpayers money.
I couldn't agree with you more. I think it's a no-brainer, and the ways in which the American people will benefit from the work that you are doing, I mean, those benefits accrue directly to the American consumer in a number of different industries and segments of our economy, as the gentlewoman from Indiana, I think, correctly articulated, and the nature of the concentration of market power in a variety of industries that impact the everyday life of countless Americans. So I'm grateful for the work you do, and would just, I guess, ask that you extend the gratitude, I suspect, of most members of this body to your team and the frontline attorneys in the DOJ that are doing that hard work. And I yield back the balance of my time.
Thank you for that. They inspire me to get out of bed every morning, and they are an incredibly talented and dedicated group of people who have delivered meaningful results to the public.
Gentleman yields back. The gentleman from Wisconsin, Mr. Fitzgerald, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Cantor, for being here. I don't want to rain on everybody's parade here, but the first thing I wanted to do was ask unanimous consent to submit for the record a letter that was received by the full committee chairman, Chairman Jordan, as well as the ranking member, Mr. Nadler. And this letter opposes
Without objection, so ordered.
Thank you. This letter opposes the FTC and DOJ's proposed changes to Hart-Scott, the pre-merger notification form, and it's got about 30-some associations and trade groups that have signed off on it. So once again, Chairman, thank you for allowing me to enter that into the record. Mr. Cantor, in June of this year, you announced that your division is changing its review of bank mergers to look beyond the traditional metrics used in bank merger review. Certainly a lot has happened in that industry since 1995. However, it appears that bank concentration levels have remained really unchanged in local markets across the country for the last 25 plus years. As I'm sure you're aware, Congress has tasked the federal financial regulators, not really DOJ, with assessing matters on financial stability and systemic risk. Making, I think, matters worse, I think the administration has been inconsistent on this issue. I'm concerned that any change in kind of the current analysis that would depart from long existing and accepted standards may not reflect actual changes in the competitive environment. So let me ask you, have you been kind of in your assessment of this accounting for increased regulatory burdens that drive consolidation and result in strong banks acquiring struggling ones in your revised bank merger guidance?
So the process for revising bank merger guidelines is still very much underway. And what the purposes of the remarks that you referred to was to say that if we're going to enforce the antitrust laws and provide assessment of competitive impact, it's important that we do so against the backdrop of today's market realities. And so in 1995, people would line up at their bank on Friday to take cash from their teller. They'd sign up for banks and get a free toaster. The role of local and community banks were different then than they are today, and that certainly fintech was not even a term that people used. And so what we're saying is that if we're going to go about conducting an analysis, it's really important that we conduct it against the backdrop of how the markets work today, and they've changed. And so I think it's an effort to bring it up to date first and foremost.
So the president's executive order on competition, it called on the AG in consultation with the Fed, FDIC, and the Comptroller Currency to kind of come up with a plan regarding bank mergers by January 5th of 2022. Can you describe that process, and was there a cohesive plan?
Yeah, so
how was that tackled, I guess, is what my question.
That process is still underway, and we're doing so in coordination with the bank regulators. As you may be aware, we are working on, as some of the other members of this committee have asked about, our draft merger guidelines. We are in the process of ingesting a large number of public comments with respect to those merger guidelines, which will also have significant instructive value with respect to the bank merger guidelines. And so we look forward to taking all of that input and working closely with our colleagues across the government to come up with sensible bank merger guidelines that are reflective of today's market realities.
I happen to be in a unique position of being, I think I'm the only member of Congress right now that's on financial services as well as judiciary. So there's a lot of discussion in both committees about this. If the agencies adopt a draft, they will reduce kind of the value of those guidelines to little more than just kind of a policy statement. Do you feel like we're in a position where you're going to be able to kind of be more public on these issues?
Yeah, certainly with respect to the, let me respond first with respect to the general merger guidelines, which are in draft form. We wrote them as a first and foremost for the rule of law. These are the first guidelines ever to cite Supreme Court cases, because ultimately we are a law enforcement agency, and if we have to adhere to the rule of law and how we enforce enforce mergers, and so or merger law, and so we have written these to be durable and tractable. But I should note that we've also submitted them for public comment, and we've received tens of thousands of comments from individuals, from businesses, from farmers, and overwhelmingly supporting our draft merger guidelines. But we're in the process of reviewing every single one of those comments and then making updates to the draft. It's an important process that we can learn and before we finalize the existing merger guidelines.
Thank you, Chairman. I yield back.
The gentleman yields back, and I'll recognize the gentleman from Maryland, Mr. Ivey, for 5 minutes.
Thank you, Mr. Chairman. Mr. Assistant Attorney General, I appreciate you being here, appreciate the great work you've been doing. It's a great opportunity to have a chance to ask a few questions of you today, but I want to start with a comment. There have been a couple of my colleagues who've talked about the Google case, and I join those views. I think those are tough cases. And I know a lot of times when people come and testify before the Judiciary Committee here, wins and losses end up being sort of how people get measured. But this is one where I thought it was important to take it on. You might lose it. I mean, it's a very tough case, but I don't want to put bad mojo on you. You might win it as well, and I think that would be a good thing for the American people. I did want to add, and I know you can't comment on it anyway because it's live litigation. I did want to ask you about artificial intelligence and what your shop is doing on that front. We've heard testimony about the need to hire additional staff overall, Carter era numbers. Mr. Nagoose hadn't been born yet in '79. Those were good days for me. I remember '79 fondly, but I did want to ask you about that, because in your testimony you mentioned that you're hiring more scientists. But it seems to me that AI is something that's really moving very rapidly and evolving very rapidly, and I'm always concerned that government isn't able to keep up with that. I want to get your sense of what you're doing to try and address that.
Yeah, thank you. So first and foremost, it's important that we understand how the stuff works. And so, AI is a term that's used to describe lots of different things, and machine learning and computer science and in a wide range of areas. There's, at the end of the day, anytime you have a significant technological transformation, it creates both opportunities and risk. And so from an antitrust perspective, we are focused on making sure that we are preserving the many wonderful opportunities that can flow from new innovations and new technologies, and so that the marketplace has the opportunity to spread the benefits around to the public broadly. With respect to AI and data-driven technologies, sometimes the aggregations of data, large data at scale, can lead markets to tip or become a barrier to entry. And so it's really important that we understand those market realities so that we can apply the law effectively.
I did want to ask you about this too, and I'm not a technological. Mr. Massie's an MIT graduate. I had to go to law school instead, but I did want to ask you about the potential of the collusion issue. I guess traditionally in antitrust law, you talk about collusion. We're really thinking about humans communicating with each other, about Mr. Buck had the 6 people having coffee together. With the AI possibility there, where there's information sharing going on that might or might not involve human conduct, that seems like that might be an area that's going to potentially create antitrust issues where you don't have the traditional human communications that you've looked at before. Let me move on to another thing real quick. I think non-compete clauses, have you discussed that already?
Yes, we have.
And how broad is that? Because that's a big deal for a lot of people who are in industries. Lawyers make sure we don't have non-compete clauses, and you can go from one law firm to another overnight. But for many industries, that's not the case. What are you doing on that?
So we have a very active program, both on the criminal and civil dockets, to ensure that we protect workers from non-compete clauses. I'll give you an example that's near and dear to my heart. We weighed in on in a appellate court proceeding in a matter involving a woman who is a fast food worker and had the opportunity to become a manager at another fast food establishment, but was denied that opportunity because of an agreement like the one that you're describing. And in a world where, in an economy where, in a country where upward mobility is the opportunity to succeed on the basis of your hard work and the merits of your hard-earned efforts, the ability to switch jobs and to do so free from anti-competitive restraints is foundational to our freedom.
Agree. I got to reclaim my time quickly. Last question. Mr. Correa asked you about the airline merger issue. And I guess the question I would raise there, because I think the point he was making was that the department's actions might have been aimed at making sure that there wasn't an impact on reducing competition, but these are two businesses that I guess are struggling economically. to what extent does the department take into consideration that, this merger might be necessary for these two businesses, or generally speaking, to remain economically viable?
And I appreciate that. I can't comment on active litigation or pending matters. We take in all considerations. We want to make sure we understand market realities. The issue that you're talking about, there's actually a legal doctrine called the failing firm defense, and so there are legal requirements that have to be met before that defense can be applied. Ultimately, we want to make sure that companies compete to offer the best opportunity and options to the public, but each case presents its own issues, and there is a very well a long and substantial body of law on how to deal with some kinds of questions you're presenting.
Thank you. I appreciate your testimony, and I yield back.
Gentleman yields back. Thank you for pointing out I don't have a law degree. I think that's...
Stop bragging now.
I've served on the science committee. I've seen what passes for credentials up here. They've given me a hard time for not having a law degree occasionally. Thank you for showing up today, Assistant Attorney General Cantor. My constituents, I've had lots of interactions over 11 years. Nobody has told me that they're worried about Google taking over their lives and asking me to come in here to Congress and do something about Google. None of my 750,000 constituents. But they do have concerns. And by the way, I've got some search engines on my phone, and they don't include Google. There are options out there. But there are things that my constituents do care about where you may be able to improve their lives or improve competition. One is airlines at the Cincinnati airport, which is in Kentucky, in my district. Another is the farmers, worried about this oligopoly that exists in the meat market. In fact, President Biden addressed it in his State of the Union, at least acknowledged the problem that 4 meat companies control 85% of the meat that's consumed in the United States. And I've also got grocers who are concerned about their ability to compete. So I want to cover some of those things. Congress vested the authority to review airline mergers with you, the DOJ, and for decades, the DOT, Department of Transportation, has deferred to you on the competitive analysis, or your department. I don't want to imply you've been there for decades. But recently, we heard the Secretary of Transportation referring to a lawsuit that you're bringing against, in the context of a merger of 2 airlines, JetBlue and Spirit. In a statement of support of that lawsuit, the Secretary of Transportation said they've not generally got involved with these merger cases, but that's changing today. So the DOT has expressed that they are now going to countermand decades of policy that Obama supported, and that they are going to basically put all of these mergers in double jeopardy. This begs the question, are you able to effectively analyze the competitiveness of these and the effect on competitiveness at the DOJ, or do you need the Department of Transportation second-guessing your analyses in cases?
When we approach these issues, we approach it as a matter of law enforcement. And so in the context of a merger, we enforce, for example, Section 7 of the Clayton Act. And so our analysis is limited to the 4 corners of that statute, which was written by Congress. There are numerous industries, including telecommunications, agriculture, and others, where there are other statutes that have other considerations and where law enforcement authority is provided to other agencies, and they can go based on the 4 corners of the...
But shouldn't in the domain of competitiveness, don't you all have the subject matter expertise? I actually serve on the Transportation Committee and had the Secretary of Transportation there and asked him what his criteria for analyzing these things would be. And I asked him 3 times, 3 different ways, and he had no answer. Yeah. I think this expertise resides in your department, not theirs. Do you agree that they shouldn't be reevaluating what you've already done?
I don't want to speak for the Department of Transportation. I can say that, again, when we look at a matter, we're looking at it, what statutes do we enforce? And so the Clayton Act is the statute that we are empowered to force at the Antitrust Division. And so our analysis is undertaken not only pursuant to the text of the Clayton Act, but the legal precedents that interpret the Clayton Act. And so our analysis is strictly within the four corners of that statute.
But my constituents benefit from low-cost carriers at the CVG airport and want to make sure they are viable, and sometimes they require a merger to remain viable. They don't control an inordinate amount of the market share, and so that's a concern that I have. Can you tell us what you've done for farmers at the DOJ?
I think we have been more active with respect to protecting farmers and family farmers than we have been in over a century. We've brought criminal and civil cases to protect the ability of family farmers to get a better return, a fair return on their crop and on their livestock. We are protecting the ability of farmers to exist in small and rural communities that have the infrastructure, whether it's a local hospital or a local bank or a local grocery store. This is the bleeding heart of our nation. Interestingly, when the antitrust laws were enacted by Congress, there was a vibrant discussion of farmers. And I had the privilege of sitting with family farmers just a few weeks ago, learning more about their businesses and the struggles that they have, and whether it's how much they have to pay for inputs, whether it's the ability or inability to repair their tractors, or the difficulty negotiating for a fair return on their cattle. These are all real issues that they are confronting on a regular basis. And at the Antitrust Division, we have brought a significant number of matters. We had a matter that we filed just a couple of weeks ago relating to meat packers and pricing. We had a matter just last week, a consent decree that will protect the ability of farmers to switch meat processors without incurring substantial penalties for taking advantage of competition. We entered into another matter. We brought another matter focusing on protecting poultry farmers from the tournament system. And there's a whole long list of actions that we've undertaken because these issues matter.
I appreciate your efforts. I think you're fighting, in some ways, a losing battle until we address what Ms. Spartz said, which is we erect barriers to entry here in Congress, and the USDA has barriers to entry. There's the same amount of regulation at a mom-and-pop processor with 4 people working there as there is at an Oscar Mayer Wiener factory. And we need not scale prejudicial regulations, but scale appropriate regulations so that these farmers, you can help them on the back end try to fight the oligopoly of 4 processors, and I appreciate you doing that. But we need to figure out how we can have little processors as well to help the little farmers. With that, my time has expired, and I really, I see Ms. Bath is here, and I recognize her for 5 minutes.
Thank you so much. I just kind of popped in on you, didn't I?
Yes.
Thank you so much.
I appreciate you coming, though.
Thank you. A.G. Cantor, thank you so much for appearing for us before us today. I'm so sorry I've been running in between committee hearings today. And but thank you for all of your work to keep our industries competitive and fair. America has prospered because of competition. And whether they aspire to grow into a large company or to remain in their communities, small to medium-sized businesses have benefited from the Antitrust Division's hard work and President Biden's economic plan. As I mentioned at FTC Oversight hearing with Chair Khan, we absolutely must uphold and enforce antitrust laws to promote competition across our industries. That means doing our homework, following the cases regarding these massive mergers and listening to those most impacted by these dealings. And the work the division does is how we protect American dollars. AAG Cantor, I want to take a moment to applaud the division's efforts in identifying and also challenging anti-competitive deals and collusion. Your work helps to protect our markets and ensure that they remain fair and competitive. I understand that the Antitrust Division needs more staff to continue this fight and the good fight to protect our markets and also to protect our consumers and our workers. As Congress looks for ways, and we always need to be looking for ways to fund the budget, I hope my colleagues become better aware of your critical work and take the step to fund your division. I think that's very critical that we look towards doing that so that we can protect our fair and competitive market. AG Cantor, I'm a huge supporter of fair market competition and find that it's necessary for our industries to prosper. As major companies begin their mergers and their acquisition pursuits, what considerations does the division use to determine if the acquisition would be harmful?
Thank you for your question, and I appreciate very much the sentiment. The American dream depends on access to markets. The American dream depends on upward mobility for workers, and the American dream depends on the opportunity of anybody in the country with a great idea to build a business, whether it's in an urban community or a rural community. And we fight day in and day out to preserve that opportunity by enforcing the antitrust laws. The considerations that go into bringing a merger are first and foremost rooted in law. Congress passed the Clayton Act. We enforce the Clayton Act. It's been interpreted for over a century by courts, and we are very much adherent to those court precedents, and we follow the law and the facts wherever it takes us. At the same time, sometimes facts change, sometimes market realities change and evolve, and that's a wonderful thing, but we have to make sure that we keep pace. That is why we're in the process of updating our merger guidelines to make sure that we can reflect and stay consistent with the applicable legal precedent, but also understand that the world as it exists today is different than it existed 20 or 30 years ago. And as market realities change, the tools that we use to understand those market realities need to evolve as well.
Thank you for that. And as these mergers continue to take place, which we know that they will, what considerations are made by the Antitrust Division to determine if suppliers, small businesses, and local service providers are actually protected?
So one of the most important things that we have done but need to do is to make sure that we're having a conversation with those who are most impacted by concentration and consolidation. And so we've taken an effort to not just make sure that we are enforcing the law effectively, but to have a conversation, to change the language of antitrust so that we can engage with those communities who are most affected, because they understand better than anyone what the effect of a transaction might be, whether it's a small business looking to survive, whether it's a consumer looking to get a lower price, or a new entrant looking to start a new business and thrive. And so we are working diligently and vigorously to make sure that we are changing the language of antitrust in our process so that it is more accessible and more open to the public.
As we always say, just go to the source, correct?
Correct.
Thank you so much. I appreciate it. And thank you so much, Chairman. Thank you for your testimony today, AAG Cantor, and I yield the balance of my time.
Thank you, Ms. McBath. The gentlelady yields back. That concludes today's hearing. We thank the witness for appearing before the committee today. I thank you for making yourself available to us between hearings as well. And without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. Without objection, the hearing is adjourned.